So this is a follow-up to a video I did earlier today about how Elon Musk and his so-called Department of Government Efficiency received a brutal smackdown at the hands of a federal judge. In order to unpack the legal nitty-gritty, I'm actually turning to a friend of mine, co-host of Live and Learn Pisco, who is an attorney, and we're also going to discuss the implications because Vice President J.D. Vance and other elected MAGA Republicans are suggesting that the judge in question should either be punished or completely ignored. It's terrifying stuff. Before we unpack all that, however, if you please, be sure to hit that like and subscribe. So, bringing on Pisco right now. Pisco, man, what the hell is going on? The Treasury Department here, I will say, is being blocked from giving access to Elon Musk, according to Axios. Doge access to Treasury data limited again. But this time it seems to be pretty comprehensive with respect to Doge. So with this in mind, can you unpack what's going on in terms of the law?
100%. Yeah. So first of all, thanks for having me on the show, Josiah. We don't have kings in this country. And Donald Trump and Elon Musk are running around the country thinking that they are above the law and they don't have to listen to the commands of Congress, whether that's in their purported deletions of statutorily passed agencies such as the CFPB, the Department of Education, USAID, or whether it's their illegal spending freeze, where they're claiming that the executive branch has the power to unilaterally pause all federal financial assistance and not follow the procedures that Congress has left out, for example, in the Impoundment Act. So it's a never-ending stream of subversion and usurpation of the other branches of government. First, it was the legislative branch, but now it's the judicial branch. And so what we had here were a bunch of groypers and tech Zoomers, 19 to 25 years old, employed by Doge, this purported agency or purported executive body out of the White House, to infiltrate the Treasury Department and actually other departments as well, not just the Treasury, the Office of Personnel Management. They went into USAID. They're going everywhere, presumably right under the pretext of an audit. But what's been actually going on is they're using data to target and destroy funding, congressionally approved funding for disfavored programs or for agencies that are investigating either Trump-affiliated entities or Elon-affiliated entities. So it's a full-on revenge tour. And these insiders, it was a lot of sort of notable news when they got access to the Treasury data, the Treasury information streams, which those are huge information streams. They contain something like 90% of all payments made by the U.S. government. They include personally identifying information of average Americans, social security numbers, tax return information, bank accounts, addresses. This is all very sensitive material, and actually only few members of one of the bureaus of the Treasury has access to this information. And the question is
Bureau
that
of Fiscal
legal?
Services, if I'm not mistaken.
That's right. Yeah. That's correct, Josiah. And the answer is according, or probably not, according to this judge out of the Southern District of New York. The attorneys general from 19 different states brought this lawsuit under various different, and that's the order right there, under various different sort of legal claims, basically saying that what's going on in the Treasury branch is illegal. Now, let me give you the sort of long and short of what they're arguing. They're arguing that it's fine, essentially, for certain Treasury members who have been approved under statute and regulation to have access to this information, but introducing and allowing for outside actors outside of the Treasury in these circumstances is illegal and problematic.
So can I stop you right there?
Legal standards, yeah.
It's funny you say that. So again, just to kind of, I guess, pre-butt this, one of the things that we've heard, one of the complaints about this particular ruling from even elected Republicans is this idea that, so wait, a federal judge is somehow barring the duly appointed Treasury Secretary Scott Bessent from accessing Treasury information. How can he possibly do that? Is that true?
That is completely untrue. The order by its terms is directed to the president and to the Treasury Secretary and to the Treasury Department. But it doesn't say that you guys can access this information. It says that these special government employees and these political appointees that are outside the Treasury Department can't access this information, and you can't authorize them to access it. And also, by the way, you should delete anything, any copies you've made of this information. They sued specifically the Treasury Department, the Treasury Secretary, and the president in their official capacity to apply to other actors. procedures. And so it's completely untrue. The problem is, and what the underlying claims are about, is compliance with, number one, Article 1 of the Constitution, because all of this, quote unquote, auditing that's going on is nothing short of a ruse. It's a ruse designed to intentionally pause the funding in complete violation of Article 1 and the structure and separation of powers of our Constitution. It's also brought under what's known as the Administrative Procedures Act. That is a statute that kind of that governs all the conduct of agencies as a general statute of Congress, and it says that you can't take certain agency action if it's against the law, which it is, because it violates certain privacy laws where, in order to, Congress enacted their own privacy regimes that forces agencies to limit what they share with other agencies as long as it's personally identified information or confidential information, except for in certain circumstances. And they have to run through certain procedures if they want to transfer that information without your consent. And so they weren't going through those checks. They weren't making necessary assessments related to confidential information in another law that Congress passed. And so this Administrative Procedures Act header is you're able to incorporate a lot of different other statutes as a cause of action for why this agency access is illegal under these sort of privacy regimes as well. And then additionally, you have the problem of essentially bypassing the normal checks and balances, the normal procedures of getting authorized to access this information, the regular Treasury regulations. And so all of this comes to a head, and it seems that the judge agrees with the rationale of the 19 states attorneys general and issued a temporary restraining order on this conduct.
So let's talk about this for a minute. So in a nutshell, for those who are laymen, I guess it's fair to say that this judge interpreted these actions by Doge as Doge and Elon Musk attempting to sidestep accountability, checks and balances, both from the other branches and, quite frankly, internally, like within the executive branch, to put restrictions, because obviously, simply because you're an executive branch employee doesn't mean that you have access to these hypersensitive Treasury information. It's not like, even other cabinet members, I imagine, the transportation secretary, Sean Duffy, probably can't access this information just on a whim. So it's a checks and balances issue. You said that the judge agreed with the rationale of the 19 states attorneys general. So I assume the federal government under Donald Trump and Treasury Secretary Scott Bessent, they were also given the opportunity to present their rationale as to why, no, Judge, you need to let Doge unfettered access to these systems. Was Doge given its chance basically to argue why it should be granted this authority?
Not just yet in a legal capacity. This is a temporary restraining order, and it's an ex-party type proceeding. Ex-party meaning only one party is presenting a case. It's kind of an emergency remedy. Basically, when there's about to be irreparable harm, you can go to court and say, hey, you need to intervene now. And so in order to get this kind of pretty extreme remedy that occurs without the other side being there in court just yet, you need to show that you are going to be irreparably harmed, which of course the states are able to do. They get millions and billions of dollars from the federal government in the form of Medicaid, right? Subsidies from the government, in the form of reimbursement for childcare type programs. So billions and billions of dollars to the states and their residents from the federal government. So of course, if Elon Musk is using this infiltration, which he is, to try to disrupt the payment of congressionally approved funding, then they're at risk. The states are at risk. Their residents are at risk. But it's not just enough to show that there's a potential harm. You need to show likelihood of success on the merits. And what the judge said was, yeah, we believe that the plaintiffs here, the state's attorneys generals, are likely to succeed on their legal case, that this is illegal for the reasons I've stated. Article 1 of the Constitution, because this is just an attempt to get around Article 1, and the Administrative Procedures Act, which incorporates a lot of these, is allowed to incorporate a lot of other legal standards, such as the Privacy Acts that I talked about, the Data Acts that I talked about. There's a Tax Act as well, where you have to have certain procedures if you're going to transfer tax information. These are all statutes that Congress passed for concerns of the American people and their data and their security. That's why these standards exist. And also, it's arbitrary and capricious under the Administrative Procedures Act. That's a term of art, which means it wasn't, they changed the policy without giving a reasoning. So even though in the legal case themselves, they haven't had the opportunity to present their brief, they could have presented an initial memo and a rationale for why they're changing the policy. But of course, they've done this as quickly as possible to try to usurp the legislative authority. And so they didn't provide a rationale in the initial instance. And so, of course, a court is going to take umbrage with that and issue this TRO. They will have an opportunity to argue their case. I think it's this Friday about why they should not be disallowed from accessing that information.
So, and again, in a nutshell for laymen, so number one, they had an opportunity when presenting Doge with this authority to effectively pre-butt legal challenges. They had to have known that were coming and say, hey, listen, this is why it's so important to give Doge the access they need. Number one. Number two, this ex parte, legal proceeding, it is commonplace. It is not like the judge is not breaking the rules by, only engaging with one particular side. This is a relatively common legal procedure. Number two, but because it's dealing with one side, the standard is so damn high for a judge to grant a temporary restraining order on this basis. You have to show imminent harm, and it's basically an emergency situation. And there will be an opportunity for the Trump administration to make their case because the restraining order is only temporary. Just so I make sure I got that clear.
That is a great synopsis. And yeah, there's a lot of times when you have these kind of agency actions, they'll release memos, and they do this and write them carefully because they know that they're subject to the Administrative Procedures Act, where their rationale is going to be tested in court under the legal standards. If you remember the DACA rescission that Trump tried to do, he tried to rescind a policy very similar to here, right? Changing the policy from allowing access only to some people to allowing general access to whoever the fuck Elon Musk wants to give access to. And really what happened there was they didn't give a good enough memo, and they didn't give a good enough reasoning in the first instance for why they should rescind DACA. And so it was undone, not because the president, couldn't get rid of DACA if he didn't want to, but because the initial memo that he wrote did not give a good enough rationale to comply with the Administrative Procedures Act. But here, there's both that APA claim, but there are substantive power issues as well related to Article 1, the freezing, and of course, the Privacy Acts and tax acts that there's a bunch of them that the states have listed. The court actually said those are the more convincing arguments, the statutory arguments. But that doesn't mean that the Article 1 argument is bad. I think it's quite good.
Well, let's get to the reaction then from the sitting vice president of the United States, because you kind of teed it up pretty well, which is, this idea that even within executive power, there's not carte blanche. There's this notion which we talk about on my channel, a unitary executive theory, which is a very common conservative legal notion. It well precedes Donald Trump. Bill Barr, Donald Trump's former attorney general, when he was attorney general under President George H.W. Bush, was a vocal proponent of it. It really has its genesis, I would argue, in the Reagan era. Donald Trump, of course, is taking it and running with it. But this idea that even though the president has broad executive power, and obviously is the peak of the executive branch, there are some rules even within that purview that he has to adhere to. So to your point, yes, does he have enormous influence over DACA? Yes, but there is a procedure. Is he the ultimate classification authority for classified documents? Yes, of course, but you can't just psychically classify or declassify information. Well, it sure seems like the sitting vice president, J.D. Vance, has had a problem with this ruling. So he says, if a judge tried to tell a general how to conduct a military operation, that would be illegal. If a judge tried to command the attorney general and how to use her discretion as a prosecutor, that's also illegal. Judges aren't allowed to control the executive's legitimate power. So let's talk about this for a minute, because I know on your channel, Pisco's Hour, which, by the way, you all should definitely like and subscribe and join. Pisco is really hitting the ground running with respect to constant or more increasing streams where he dives, yes, into politics, but also from a legal perspective. You should definitely check it out. But you've been making the case that we are either in the midst of or on the cusp of a constitutional crisis. So let's talk about this. Is the sitting vice president of the United States suggesting that a federal judge's order is illegitimate and suggesting that the federal government disregard it? Do you think this is fodder for a constitutional crisis?
We are in a constitutional crisis, Josiah. We have been. And that's because the president of the United States is attacking the other branches of government, and it's an existential fight. So he started, like I said, by attacking the Congress, by trying to unlawfully freeze their spending, just delete the agencies that they've implemented, and ignore the procedures that they've set out. But we know also that they're going to attack the judicial department. J.D. Vance previously said that Trump should ignore the courts. He said he should behave like Andrew Jackson, where there's this apocryphal, which means, dubious in terms of whether he actually said it, statement of John Marshall has made his ruling. Now let him enforce it.
Yeah, it's
Is
referencing this idea that the Supreme Court can issue its proclamations, but given that it doesn't directly control law enforcement domestically or the military, it doesn't really have the force of enforcement. It relies on the executive to comply in good faith.
Correct. And so he made that statement before the election. Everyone saw it. We knew it was coming. And we know that it's bullshit because, of course, Marbury versus Madison says it is emphatically the province and the duty of the judicial department to say what the law is. But they don't care. And Project 2025 doesn't care. The authors of Project 2025, who are now in positions of great authority in the administration, don't care. And they want the president to be a king. And so what you see now is completely in line with their belief of executive supremacy and that they are above the law. You started to see it, in their rhetoric, obviously, but in the spending freeze context, they issued a rescission of the spending freeze memo. But then they said, we just rescinded the memo, not the policy.
And actually, it was Caroline Leavitt, Trump's press secretary, who said that. Right. And then that was used, if I remember correctly, as fodder for a restraining order by the judge because the judge was presented with Caroline Leavitt's tweet saying, this is just a pretty transparent attempt to sidestep judicial review. You're going to be that you're at risk of having this policy rejected. And so you're trying to engage in some shenaniganry here to avoid judicial review. And it ultimately created the scenario that they were hoping to avoid, which is the judge issuing against them. However, there have been credible reports, Pisco, that the Trump administration is simply disregarding the ruling.
Yeah, no, I totally believe that they'd probably disregard that ruling. That I wouldn't put it past them. The judge, right, when they do this little duplicitous, we'll rescind the memo but not the policy. What they're trying to do is make it so that it's unreviewable. The judge called them out and said, I have never seen anything so disingenuous, that it's based on quote unquote false pretenses, that it is a blatant and naked attempt to avoid lawful judicial review by the courts. I mean, they, in stark terms, the language here. So all the alarms are sounding right now, and everyone can see it, what's happening. And so people who are telling you, it's okay, it's no big deal, these people need to be disregarded. The administration is signaling that it's going to ignore Congress and it's going to ignore the courts. What they want is a king. And in this country, there are no kings. And I'm not going to sit around and wait for them to install a king before I start sounding my alarm that we are in a constitutional crisis in this present moment. And so you need to guard yourself. Do not panic, but be aware of the enemy and of what they're trying to do and who they're posturing in front of you to try to tell you that it's all okay.
So, again, the J.D. Vance, as you said, I pulled up a Wall Street Journal op-ed. The Wall Street Journal, a conservative publication, a sister publication of Fox News. They even said that J.D. Vance disregard for the rule of law. They gave an op-ed as to why he would be unfit to be vice president of the United States for precisely the reasons you provide. I will say, as somebody, you and I have had longstanding discussions and debates about this. This is a really complex issue for me because on just a principled level, I am uncomfortable with the notion of judicial supremacy, this idea that the court can impugn checks against the other branches, but it receives none itself. We do have to, I think, radically rework it. That's why I'm such a proponent of ethics requirements and recusal requirements where it's no longer at the judge's discretion, because if the court is going to issue orders to the executive, I think the court should be held to even higher standards morally and ethically than the executive. This kind of hits an interesting spot for me. Yeah. My beef, of course, with J.D. Vance on this particular issue is he doesn't have a principled objection to the notion of judicial supremacy. He was perfectly content for a right-wing Supreme Court to strike down the Biden administration and their rulings left, right, and center. That's okay. That when it's a Democratic administration, the courts are supreme and the courts can issue whatever edicts and Democrats are obligated to adhere. When it's a Republican in office, the rules apparently change. And this is why they don't have a particular principled objection to the notion of judicial supremacy. It's simply about specific outcomes. But let's talk about this one other thing here, which is I keep hearing, well, listen, what we're calling for right now, disregarding the rules, disregarding the rulings of judges, liberals, is actually playing by your playbook, and it was Joe Concha from Fox News replying to Dan Pfeiffer of Pod Save America, replying with a screenshot saying how Biden is continuing to cancel student loan debt despite Supreme Court ruling. Can you address this? Because this is something I have heard for years, not just now, but this idea that President Biden, he's disobeying the court. He's disregarding the court. He's defying the court, Pisco, because the Supreme Court said that he couldn't use a particular authority to cancel student loan debt. And so then he cited a different authority to do a different version of student loan forgiveness. Can you debunk this bullshit?
It's a complete and total lie. Anyone who tells you this, you need to disregard. You need to disregard them because they are giving you a lie, a pure piece of regime propaganda, and it's easy to debunk. So yes, that means the MAGA people who are telling you this are lying to you, and that includes, by the way, MAGA News, which includes the Wall Street Journal and its editorial board. When they say something like Biden is defying what the Supreme Court said, they're lying to you. And how could I say that, right? How do I know that? Well, I never got my $10,000. I lost out on my $10,000. Guess what? It didn't come back. When Joe Biden's policy of this $10,000 student loan forgiveness, universal, was struck down by the courts, illegitimately, in my opinion, I think that Biden had the better of the arguments about why it was lawful, but he abided by that. And the proof of that is I never got my $10,000. And I know a lot of you didn't get your $10,000. What he did instead was, okay, they struck down this universal program. Let me use other sources of authorities to do much different things under different methods. That is not disregarding a court order. That would be preposterous to say so. If you say so, you are denying basic reality, which is the $10,000 never came into my student loan accounts. I never got that money. And you can literally prove that this is a lie.
You definitely debunked the lie. What about the notion, okay, Pisco, fine, but the implication was that President Biden can't forgive student loans, and you're just exploiting a technicality. When they said you couldn't use this particular authority to use for this particular program, that meant that Biden should have said, okay, fair enough, and not forgiven any student loan whatsoever. What do you say to that? Because I know what I say to that. Because that sure sounds like judicial supremacy.
Yeah. So that would be an absurd exercise of judicial authority if that were to occur. It would be saying we get to review questions that are not before us, provisions that we're not asked to review, that we haven't been briefed on, right? On policies that don't even exist yet. The court would not do, even this Supreme Court is not going to go that far to say every single kind of student relief, no matter how broad, no matter how narrow, no matter what the source of authority is, no matter what the circumstance is done. I mean, that's an absurd thing that a court could do. And even this court, which sometimes goes way beyond what's before it, would not go that far beyond what's before it. I mean, that's just crazy. And it didn't happen. They were reviewing a particular action. That particular action was briefed, and it was under a particular authority. And so they ruled on that action. And in fact, that action had to do with the specific statutory language involved in one of these acts. I think it's the CARES Act or the Higher Education Act that said, waive or modify any provision of this title. And so it had to do with specific language in that specific law. And so when it's that narrow, a statutory argument that narrow, it would be preposterous, a lie, a deliberate, malicious, intentional lie for anyone to tell you, well, the Supreme Court said no student loan forgiveness of any kind. That is crazy. And that's why I'm telling you, if anyone is trying to make that argument, you need to disregard them completely. They are liars.
No, I love it. Yeah, absolutely. The president was perfectly within his legal right to say, okay, you've ruled on this specific thing, but I have every right to pursue alternative means. And if it's reviewable and you strike them down, we'll deal with it then. But this goes back to, again, the selective notion. It's Schrödinger supremacy, this idea that when a Democrat's in power, the Supreme Court is not only supreme, as in it can give orders to the president's its bitch. But in all instances, when the Supreme Court says you can't strike down, that you can't do this, you can't do that, it applies universally. Of course, then when a Republican takes the White House, then things are very, very different. So yeah, I appreciate you coming in and going through this situation. It does sound like we are in the midst of a constitutional crisis. And do you want to give a shout out to any of the conservative attorneys with whom you have recently sparred? You don't even have to name names, just any conservative attorney or who would tell you, Pisco, you are overreacting. The Trump administration clearly has respect for the relationship between the executive and the judiciary.
Absolutely. So my channel is Pisco's Hour, and on that channel, it's a brand new channel, and we're growing really big. So I would really appreciate if you guys wouldn't mind subbing to that channel. It's Pisco's Hour on YouTube, and on that channel, I recently just had a debate with a bunch of conservative lawyers where they promised me and assured me that we are not in the midst of the constitutional crisis. Yeah, don't worry, the Trump administration is not going to defy court orders. They're not trying to steal, congressional authority to appropriate and make spending laws. Completely wrong. I'm completely vindicated. And everything they're doing now, which is making apologia, which is downplaying, which is de-emphasizing, is a complete disgrace to the practice of law and to their oaths to support and defend the Constitution of the United States. In the strongest possible terms, I condemn the Vice President of the United States for his statement, and I condemn the President of the United States, either Donald Trump or Elon Musk, for pursuing this constitutional deranged program and signaling that they're going to defy the courts.
Yeah, and we're only 3 weeks into this administration, so there's no telling what'll happen at the 3-month mark. But yes, Pisco, I appreciate it. Thank you. Please be sure to like and subscribe on Pisco's channel, and catch us on Live and Learn, I think every Wednesday at 7:30 p.m. Eastern. So appreciate it, Pisco.
Later. Thank you.